subpara B and C of paragraph 221 of the judgment of this court dated 15 February 2024, the direction to the SBI to submit details of bracket 1, the electoral bonds purchased, semicolon, and bracket T 2, political parties which have received contributions through electoral bonds, is specifically since the date of the interim order dated 12 April 2019. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12 April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance for it?
What is it that you want clarification?
Yes. Marat, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Marat, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Marat. There is no mismatch, there is nothing of the sort. If your lordship sees that table.
Not going to all that. I mean,
I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024, this court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the electoral bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. These directions in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions through electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019 till date to ECI. SBI was required to disclose details of each, underline each electoral bond encashed by political parties, and to include inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and the plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that the that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression to invert commas, include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. Full stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of, and the serial number, if any, of the bonds which were purchased and redeemed. Full stop.
You were voting number 1, did we?
The application, this was on your application, I think you had moved this, no? The application was by the applicant. Oh yeah, we had, therefore, Mr. Harishan Salve, Leonard Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
Could we have one more day, Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
Mr. Given to the Election Commission.
In terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI. And,
So, I was only saying that Your Lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the Election Commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not addressing your lordships, he is addressing somewhere else. Kindly hear him for some time. So that it comes forward in the newspaper tomorrow, that Mr. Prashant Bhushan vehemently said this. That's the purpose.
Solicitor, unfortunately, public interest litigation have now become publicity interest litigation.
It is publicity interest litigation. It is, my lord, there are some hidden agendas. There is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships in your lordship's majesty would not know, my lord, what are the hidden agendas behind it.
Just dictate a short order. I think, we are unnecessarily expanding upon the remit.
Because the major political parties have not disclosed the donor.
Just give us 2 minutes to
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
They filed an
Mr. Hansaria, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes.
Right? In our interim order, we said that the disclosure shall be made with effect from the date of the interim order,
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitutional Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice. What we told Mr. Rodgi, Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the
So
judgment.
the only reason why I'm
You
saying
can't
that,
modify that date.
no, the only reason, because your lordship asked the political parties to give donor details to the election commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems, a lot of your issues will
But
get
for
solved.
that period of 2018 till
Oh, that will.
April
we are not sitting in a
29,
review.
We have taken a conscious decision.
we are
Please
faced
try
with a
to-
situation where the
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
no,
And
in the light of the disclosure which has come to light of the political parties, that's why I'm saying.
And it is not a
If
clash
the
of
political
interests.
parties had disclosed the donor details, this would not be required.
draw the line somewhere, we had to hold the balance. We've held the balance ultimately.
As your
as
lordship
well.
pleases, but I just.
Can I just add one sentence? I'm just pointing out what details can be there. First is serial number, second is the date, the third would be alphanumerical number, fourth column would be name of the donor, fifth column would be the name of a political party, and sixth column would be the amount. Well, this will cover all the details, not in my respectful submission.
My lord, this is now asking us to sit down and collate one
This
with
is
the
a
other.
submission made to the court, just like Mr. Salve made a submission to the court. Very well, I'm making a submission to the court, Mr. Salve, asking us to do whatever. Look,
Please permit the, my lord, the chief justice to dictate the order now at least.
Secondly, my lord, the lordship said, lordship has seen that IA, my lord, I filed that IA. For a pre-period, if a lordship have taken a conscious decision on that aspect of the matter, my lord, lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only, because we said, my lord, it should be, my lord, otherwise logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter, then,
That's-
very well, I'll leave it at that.
And there is a specific direction with effect from 12th April.
Then your lordship said, my lord, I have not pressed the application.
So Bhushan, there will be no end to it.
What is the IA number, Mr.
By
Hansaria?
way of-
Just one second, Mr. Bhushan. IA number which you are not pressing is IA number?
Diary number 12580-2024, which is MA number, MA diary number.
So that you are not pressing.
Yes, my lord.
Just
Just
one,
say MA
by way of
diary number
information on
580-2024. Mr. Vijay Hansaria, learned senior counsel appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of
one
Lord,
thing.
whatever proceedings have gone to the court, in view of the proceedings before,
Whatever in view of whatever.
Lord, if your lords, you can say that. my lord.
But
Otherwise,
in view of what? In view, we'll say, in view of the specific directions contained in paragraph 200, in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
just one fact by way of information.
Enough of assistance by this public spirited person, my lord.
The details-
Your lordship doesn't need any further assistance.
The details of the number of bonds shown by the, in the data. which
He is
has been
gathering the
submitted.
details for a future PIL, my lord, so
The
that
number of bonds-
remains in,
the
he remains
number of-
relevant.
Now please permit the, my lord, the chief justice to dictate the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores and the amount redeemed is 12,769 crores, that is 550 crores more than what were purchased. Now the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, Malad, these figures are not authentic. I have given the authentic.
18,000 versus
roughly
22,000
22,000.
NGOs are, my lord, fudging the figures and bringing their own, my lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein, that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that 18,000.
This is what happens
Okay,
when
we'll now
it,
leave it at that. I will.
Malad, those numbers are not right. Since, Malad, because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.